Hi everyone, I welcome you all on this channel, that is Shine in Law with Dr. Mithun. Today we are discussing the very important topic from the concept of federalism, or from the module that is known as a federalism, that is Interstate Water Dispute Resolution Mechanism. There are certain provisions in the Constitution which provides for strengthening the relation between state or the interstate or between central and the state government, and in that article 262 provides for the very interstate water dispute resolution mechanism. And under this provision we understand that how in a cooperative manner center and state or state inter se they can develop their relation and they can develop with their resources in their respective territories. So today we'll discuss about this interstate water dispute resolution mechanism. Now rivers, they are cutting across the territory of one state and they are entering into the territory of another state. And there might be possibility that on the basis of sharing of water, one state may have a dispute with the other state. In such particular circumstances, how to resolve that particular dispute, how amicably we can settle the very dispute between two or more states, that mechanism is rightly provided in the Indian Constitution. In India, all major rivers are interstate rivers and their waters are shared by two or more than two states within the territory of India. Now basically after independence, we understand that there is a growth of population also, urbanization taken place, industrialization taken place, and due to all these new developments, we understand that there are several interstate water dispute about sharing of water has taken place. And in that we can rightly name few such water disputes between that particular state, like Kaveri water dispute, जो कि तमिलनाडु, कर्नाटका एंड केरला इन स्टेट के बीच में है. देन कृष्णा वाटर डिस्प्यूट जो महाराष्ट्र, कर्नाटका एंड आंध्र प्रदेश इन स्टेट के बीच में है. देन गोदावरी रिवर वाटर डिस्प्यूट बिटवीन आंध्र प्रदेश, मध्य प्रदेश, छत्तीसगढ़, ओडिशा, कर्नाटका. देन नर्मदा वाटर डिस्प्यूट है, यमुना वाटर डिस्प्यूट है, एंड सो मोर. नाउ there are certain efforts, or there were certain efforts taken by the central government to resolve these particular dispute in an amicable manner through negotiation between that respective states. But in some particular dispute we understand that there is a need of adjudicatory mechanism, and to that effect with the very provision, or with the help of the provision of article 262 of the Indian Constitution, the very formation of tribunals for the adjudication of interstate water dispute has been taken place. And through that we understand that the tribunals were constituted in regards with the such particular interstate water dispute, like Godavari water dispute tribunal, then Krishna water dispute tribunal, then Narmada water dispute tribunal, then Ravi Bias water dispute tribunal. Then in regards with the Kaveri, there was a tribunal constituted. So Godavari, Krishna, Narmada, Ravi, Bias, Kaveri, New Krishna, these are the rivers. In regards with these rivers, to resolve the interstate dispute, there was a constitution formation of tribunal on the line of article 262 has been taken place. Now when we see that these particular rivers or the water interstate water dispute, we have to understand what actually provided in article 262 of the Constitution as a very basic constitutional provision for the resolution of interstate water dispute. Now article 262 provides that Parliament to provide by law for adjudication of any dispute or complaint with respect to use, distribution or control of the waters of any interstate rivers and river valleys. So this provision authorizes Parliament, that Parliament can make the law in regards with the adjudication of any dispute or any complaint with respect to the use, distribution and control of the waters or any interstate waters or interstate rivers or river valleys. Further, Article 262 Clause 2, it again authorizes Parliament that Parliament by law provide that neither the Supreme Court or any other court has the jurisdiction in respect of such dispute and complaint passed by the River Boards Act 1956 and the Interstate Water Dispute Act 1956. Clause 2 of this particular Article 262 provides for that Supreme Court is not having any jurisdiction for entertaining any such particular interstate water dispute, as the exclusive jurisdiction is there with that particular legislative mechanism which enacted by the Parliament as per the act which is known as the Interstate Water Dispute Act 1956 or the River Boards Act 1956. So under these two particular acts, whatever mechanism is made by the government, on the basis of that particular resolution, we can solve that particular interstate water dispute in between the states within the territory of India. Now this particular act empowers the government to set up the tribunal for adjudication of dispute. Decision of tribunal is always considered as a final and binding on the respective parties of that particular interstate water dispute. No other court, including even the Supreme Court, shall have the jurisdiction to adjudicate or to resolve such particular interstate water dispute. So exclusive power is recognized with the Parliament and the Union government to resolve interstate water or interstate river dispute within the territory of India. Legislative power we have to here understand, or in this particular adjudication of interstate water dispute, have to consider as a superior than that particular judicial power within the territory of India. Now on the line of this particular Interstate Water Dispute 1956, that this particular act is enacted under Article 262 of the Constitution. Under Article 262 of the Constitution, the Interstate Water Dispute Act 1956 made by the Parliament, and the very basic features of this particular act, that it provides for such particular mechanism of a tribunal, and the tribunal under this particular act is having a same power as like a civil court, what we are understanding in the ordinary judicial course of action. Now under this particular act we have to understand the other features, that this act have the power to make schemes for implementing decisions of tribunal, dissolution of tribunal, and power to make rules. Under this act, there is the authority to adjudicate on the matters related to water dispute. Further, there is a bar of jurisdiction of Supreme Court or any other court. Under this particular act, central government is empowered to constitute tribunal on complaint of the state government. They can find a solution midway for the benefit of both the respective state involved in that dispute. Then they can investigate the matter and forward the report to the central government within a period of 3 years. And if at all there are the circumstances because of which they are not able to send that report within 3 years, then on a reasonable ground, the extension of 2 years can be given to such particular adjudicatory authority. Tribunal consists of a chairman and 2 other members nominated by the Chief Justice of India from the judges of the Supreme Court or from the judges of the High Court. Now decision of such particular tribunal is always considered as a final and binding. Apart from this, under entry 56 of the Union List, there is a enactment which is known as the River Boards Act 1956. Now this act enacted for establishment of river boards for the regulation and development of interstate river and river valleys. But unfortunately we understand that no river board till date constituted by the central government. The river board is of only advisory in nature under this particular act. This river board can acquire hold and dispose both movable and immovables. It can undertake preliminary investigation or surveys. It has a power of inspection of any work undertaken by the government interested concerning the regulation or development of the interstate river or river valleys. It can conduct and coordinate research on various aspects of that conservation, regulation or utilization of water resources. It can publish statistics or other information relating to the regulation or development of the interstate river or river valleys. Decision of the arbitrator shall be final and binding on the parties to the dispute and shall be given effect to by them. So these are the very basic features of this River Boards Act 1956, what we understand from this particular mechanism. So to strengthen the concept of federalism and in a cooperative manner to develop the every states and the territory of every state with that particular consumption or with that particular resource of the water, we understand in a cooperative manner for the development of entire nation, this concept of interstate water dispute resolution mechanism is considered as an instrument for each and every state within the territory of India. So with this, I hope ये वीडियो आपको अंडरस्टैंड हुआ होगा. अगर ये वीडियो आपको अच्छा लगता है तो आप ज़रूर इसको लाइक करें, शेयर करें और चैनल को सब्सक्राइब करना ना भूलें. थैंक यू वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.